everyone. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. Usually I like to talk about things that have happened just within the past week, but sometimes immigration takes a little bit longer. Okay, usually immigration takes a little bit longer than a week. So we do talk about things that have happened outside of the past week, but I do absolutely like to give you the update and what's happened in the past week. So with that said, I like to dive right in. The first thing I want to talk about is for my employers. If you are an employer, you have W-2 employees, if you did remote review of your I-9 documents at all during the pandemic, beginning in March of 2020, this is for you. So if you did remote review of your I-9 documents from March 2020 to present, to like today, those flexibilities, the flexibility of being able to review documents remotely, is ending at the end of this month. So on July 31st, that ends. So after that, all new hires need to be processed the regular way. You need to be looking at their documents in person that they are using to support their I-9. Immigration Service is giving employers until August 30th to be fully in compliance. That means all of the I-9s that you reviewed remotely, all of those remote review documents, where you didn't actually see the physical document, all of your I-9s need to be updated by August 30th. I suspect there may be some audits, some spot audits coming as a result of that to make sure that employers have complied with this. But those flexibilities end at the end of this month on July 31st, and you have until August 30th of this year to be fully in compliance with that. So the flexibilities were always going to be temporary. If you need help kind of figuring out maybe what your process should be, what that should look like, let me know. Please reach out. If you have W-2 employees, you're running payroll on them, and you have no idea what an I-9 is, reach out to me as well. We should have a conversation about that because you should have your I-9s on board and completed. So next thing I want to talk about this morning is the visa bulletin for August. I've seen a lot of digital ink being spilled. This has been a topic of conversation with my clients, employers, and other immigration attorneys. The visa bulletin has a lot of people concerned about the length of time that it's going to take them to get their green cards. The visa bulletin is the bulletin that we look at every single month. Every single month when we are processing green cards. The visa bulletin essentially tells us where the Immigration Service is in line when it comes to processing your green card. The Immigration Service is only allowed to approve a certain number of green cards every fiscal year. And every fiscal year, ever since I've been practicing for 25 years, there have been more green card applications in the pipeline than there have been spots available. So the State Department does this very, very complicated system where they predict how many applications they can accept, and then that will ultimately get approved worldwide so that they can meet that number every single year of how many they can process. So as a result, every month we get a chart and it says, individuals from X country can file their green card application if their priority date is before a certain date. So those dates move forward and they move backwards. When those dates move backward, we call it retrogression. We saw quite a bit of backward or retrogressed movement in the visa bulletin for the month of August. Of note, the EB1 category has now retrogressed worldwide, and we've seen further retrogression, again, backward movement for individuals from India for the EB1 and EB3 categories. So, as I said, these dates and your place in line and where USCIS and the State Department are processing change every single month. So The new fiscal year begins in October. Generally in October, for that October visa bulletin, we tend to see some forward movement. So they have actually put in the notes of the bulletin that we should see some forward movement, probably back to the July dates for some of these categories. So it's, August is not looking too optimistic. However, this is not the first time this has happened. Dates do move backward, they do retrogress. So we just kind of have to sit tight, and hopefully they will start to move forward at that, at the latest period, hopefully by October, but certainly hopefully sooner than that. Hopefully September we'll see some forward movement. Fingers crossed. But that is the skinny on the August visa bulletin. I haven't seen a single person that's particularly happy about it, but at this point, sort of is what it is. We're working through it. We're letting people know we're coming up with options for people, if they can, to stay in the U.S. and stay work authorized. I know I have looked at all the files in my firm, to make sure that we have a plan for people to remain work authorized. But if you have any questions about the visa bulletin, how it works, how it will impact your application, feel free to reach out to us at the firm, and we're happy to get a consultation together with you, and and kind of go into more depth and detail with your own specific situation. The next thing I want to talk about is Florida. Florida Senate Bill 1718 went into effect July 1st of this year, so at the beginning of this month. For those employers that are in Florida and have 25 or more employees in Florida, you now must be using E-Verify. E-Verify is a government system. It's a government-owned system. It is an immigration-owned system that helps employers determine whether or not an employee is work authorized in the United States. E-Verify system pings off of Social Security and Department of Homeland Security databases to look for and to confirm work authorization of your employees. It is important to remind people that because you must use E-Verify does not mean that you no longer have to complete I-9s. They are two completely separate programs. So all employers must use the I-9s. In Florida, only those employers that have 25 or more employees have to use E-Verify. So if that's confusing, reach out to us. Again, we'll happy to have a conversation with you about that. We want to make sure that you are fully compliant. If you are found to be non-compliant, and again, this is only for Florida businesses, if you're found to be non-compliant, meaning you have 25 or more employees and you are not signed up and using E-Verify, you will be given 30 days by which to comply, meaning 30 days to sign up and start using E-Verify. If you do not comply, you can be fined $1,000 a day. So that is a $1,000 daily fine if you are found non-compliant and then do not become compliant within those 30 days. State agencies can end contracts for businesses that are not in compliance with this E-Verify requirement. So keep that in mind. If you're a business and you have a government contract with the state of Florida, if you are not using E-Verify and you have 25 employees or more, you can lose that government contract with the state of Florida. SB 1718 also invalidates driver's licenses issued from other states to individuals that are not documented here in the country. So while those driver's licenses will be valid in the rest of the country, the state of Florida has decided that it will not recognize them. So keep that in mind as well. Because of SB 1718, I fully suspect that we will see more raids of work sites and also more I-9 audits and checking to make sure that people are using E-Verify. So if you have questions on that, if you have questions on how to be compliant in your business in the state of Florida, let me know. Again, we can get set you up with a consultation and see how we can best assist you. Next up on my list of things to talk about this morning is USCIS is becoming a teeny bit more digital, and I'm kind of excited about it. So USCIS they've come out with a list of things that they are working on, that they are hopefully going to release soon, that we can, in ways that we can interact with them online via email, as opposed to having to call the toll-free customer service number and stay on hold for a very long time. We are looking at being able to hopefully very soon reschedule biometrics appointments. They have made it very clear that is only going to be honored 2 times for your case. So hopefully we will be able to do that quickly online. They are working on the capability of allowing us to change your residential address online. That will need to happen through your My USCIS account. So if you don't have a My USCIS account, you may want to get one in anticipation of this coming out. It is also just a good thing to have, and it is a place where you can check the status of your applications, assuming that you mirror your application into your My USCIS account. We are looking at being able to hopefully very soon schedule certain appointments, request certain appointments online, not schedule. Hopefully we'll be able to request certain appointments be made using their online system. And so the added stamp or the 5551 stamp or the green card stamp, all phrases used interchangeably depending on what you're reading. That is a stamp that is needed if for some reason your current green card has expired, the physical card itself has expired, but your status is still there and valid. You just need documentation to prove that you're a green card holder. You want to get an I-551 stamp or your added stamp or your green card stamp, again, all used interchangeably. So hopefully we'll be able to see soon where we can request those appointments online, as well as emergency advance parole or travel permission applications online. So hopefully we'll be able to see that system up and running very soon. They're also implementing a text ahead system. So again, instead of staying on hold on the phone forever and a day, they are implementing a text ahead system when we need to interact with what they call a tier 2 officer online. So those are all, I think, good things. Once we get them up and running, it's technology. There will be some issues. Tweaks will need to be made. That is totally fine. I am perfectly happy with working with them through the tweaks, as long as we have a more efficient way to work with the agency. So I, for one, am quite excited about those and can't wait for them to come out. And the last thing I want to talk to you all about is the national interest waiver tip. I've been getting a lot of people hit my inbox and asking some more questions about that. So the next thing I want to give you all as a tip for national interest waiver is this. You do not need to be in the United States in order to process your national interest waiver green card. You can, in fact, be living and working outside of the US. So for those of you that may not know what the national interest waiver green card is, it is a second preference category green card application. The second preference typically requires that an individual have a master's degree or higher. If you don't have a master's degree for national interest waiver, then you need to show that you have exceptional ability. Once you meet that threshold, then you need to show the Immigration Service that your proposed job, your proposed endeavor, has both substantial merit and national importance to the United States. Second, that you have the capability, once your green card is issued, to continue in your field and move it forward and continue to have substantial merit and national importance in your role. But you need to show that the Immigration Service that you have the capability to do this. Do you have a business plan? Do you have 15 or 20 years of experience? Are you the leading person in your industry? So that kind of thing. And third, you need to show the Immigration Service that on balance, it's beneficial to the United States to waive the regular EB-2 requirements. Those requirements that are being waived would be having a job offer, because you can self-sponsor your national interest waiver, meaning you don't need an employer to sponsor you. You can certainly have one, but you do not need one. And we're asking the Immigration Service to waive the labor certification requirement, which essentially is also asking them to waive the requirement that a U.S. citizen be sought after, that the job be advertised, and that we look to see if there are any U.S. citizens that are available for the role and qualified for the role. So you're asking the U.S. government to waive those very core requirements of an EB2 category. So in asking them to waive that, we need to show that we meet those requirements. So if you are outside of the United States, you are eligible to file a national interest waiver green card application. So that is the tip I have for you today on national interest waiver. And that is all I have for you this beautiful Monday morning. If you have any questions about your U.S. immigration, how to sponsor someone to come work for you, you have a candidate, you just don't quite know what the immigration process looks like, we are here to help you. If you're in the middle of that process and you're feeling a little stuck, we are also here to help you. If you have a request for further evidence and you're not quite sure where to go from there, we are here to help you. So feel free to reach out. You can give us a call, 954-903-1337. You can also send us a message, and we will get back to you. I am Carol Williams with Williams Immigration. This has been another Monday morning edition of Beyond the Soundbite. Have a great rest of your Monday, and